So let's say you settle your personal injury case for $100,000, but now your own health insurance company is coming after you and saying, we get to be paid back out of the settlement you just got. Can they do this? How does this work? How can a personal injury lawyer like us help you through this process if you get there? So today we're going to talk about that. So here's how it usually happens, right? You have the unforeseen accident, you're in a car wreck or whatever it is. Your health insurance steps in and pays for your care. You go and you get a settlement, and then the unexpected request, right? The health insurance company comes back to you and says, pay us out of this amount of money. So what is subrogation, right? That is the key thing to understand. So subrogation is basically a form of reimbursement. They can get back the money they paid for your medical care from your settlement. So when you get a settlement, the person or company with the lien must be paid their portion before you get the rest, right? It's not optional, it's legally required. And in some situations, they can even come after the law firm if this doesn't happen and if they don't get paid. So common example, right? If your health insurance paid $15,000 for your medical bills, they can place a lien for $15,000 on your settlement to make sure they get that money back. Why does this happen? From the insurance company's perspective, this is about preventing a double recovery. If they paid benefits to you, and then you had the other party, the third party who caused the car accident, let's say, pay those benefits, they view that as a double recovery if you don't have to pay them back. Now, of course, I don't really see it this way because you've been paying those health insurance premiums for exactly this situation. But in any event, this is the theory and this is why they can be paid back. So who can make a claim on your settlement? Private health insurance, this is very common. If you get healthcare through your employer, they will have a lien usually on your proceeds from a settlement. Medicare, this is a big one. That's a very complicated federal regulatory scheme. Don't want to mess around with them. That's the feds, and they have all sorts of rights. Medicaid, sort of the same thing, very related. Hospitals and doctors will sometimes put a lien on your case. They'll sometimes file a lien in a court of law. These liens, you have a little bit more leeway in terms of how you can get those resolved. You don't have as much argumentation you can make to reduce those other liens, but these liens are a little bit easier to get resolved. How much can they actually take, right? So usually just what they paid, and that's always going to be less than the actual top line charges. So you might have a situation where the medical bills are charged at, say, $100,000, but what was paid is $30,000 or something like that, so greatly reduced. Usually the lien is just what they paid. They usually cannot come after your entire settlement. It's very rare. In fact, just personally speaking, I've never seen it happen, but it's a huge obstacle sometimes in some cases where that lien is perhaps more than the available coverage or certain other situations. So can you fight to reduce the lien? Yes, you can, and it's an underrated piece of our jobs as personal injury lawyers that we're often dealing with lien holders or subrogation agents. So one of the ways that we do this is by going through with a fine-tooth comb all of the charges and bills that they claim they're entitled to be paid, and then analyzing that and saying, well, that's not really related to the accident, or you were going to need that care anyway. There are certain arguments we can make saying that those bills are not actually related to the accident or the injury that you got compensated for in a settlement. The next thing you can do is argue that the billing rate is too high. And then a big one is demonstrating that you didn't get full compensation or you weren't what's called made whole. The made whole doctrine is really important. As I'm making this video, and one of the reasons I made this video is we just got a settlement check in the mail today. It's a policy limit settlement, but the amount of that settlement is actually less than the medical bills. So this client was not made whole, even though we got the most money we could possibly get in terms of we got maximum policy limits offer. The bills are still higher, and Medicare is out there saying we have to be paid back. So we can try to argue that they weren't made whole. We can try to argue other reductions, attorney's fees based reductions and things like this to try to get our client the most net recovery we can possibly get. So what should you do if you receive a subrogation questionnaire in the mail? The first thing is don't ignore it, right? You need to respond and you need to provide all the information you can because you don't want to create further problems down the line. But you don't have to pay it immediately. And that is often the case. Like I've used this example. Today we got a settlement check. We don't have the lien finalized. We're going to go through a process now of getting that reduced. And it's actually kind of common, not always, but common, that you will still be resolving the lien even after you have settled the case in principle with the at-fault driver, just to use the car wreck example. So it can take a little bit of time to negotiate it down. Sometimes the lien holder takes a long time to investigate the claim, and you've actually settled the case before you even know what the lien holder is going to say is their total lien. Sometimes we can't settle the case because the lien holder hasn't told us this number, and we're trying to figure out, well, what are you going to demand to be paid back? Because that's going to affect whether we can even settle this case in this range. So the point being, you don't have to pay it immediately, and an attorney can kind of work through the process with you to try to bring that number down. So the next point, tell your lawyer everything. Make sure the lawyer has copies of your policy, all of your medical bills, all of the providers you went to. The last thing you want is, you didn't tell me that you went to some clinic over here, and now there's a bill for that, and it wasn't part of the settlement, and now we have to undo something, and it's a big mess. So make sure the lawyer has all the information related to your care and all the different coverages you have. Along those lines, keep all your documentation provided to your lawyer. So as I've said, this is a very underrated problem in personal injury law, this whole idea of liens and subrogations. It's one of the biggest functional limits on your net recovery, right? People talk about settlements and the top line settlements, but what you care about as a client, as a personal injury victim, is what do you walk away with? And one of the biggest things that reduces your recovery is liens and subrogation. If you want to get your free guide for what to do if you've been in a car accident, click the link in the description. Thanks so much for watching.